Welcome to Clause 8. You're watching a short clip from one of our full episodes, featuring real conversations with the leaders shaping IP.
We've had some, in my view, absolutely catastrophic. The evolution of the case law over the last 20 years has been catastrophic also in expanding the doctrine of fair use to something that's just, vitiates copyright. And you see it in AI. I mean, I guess one reason I'm not worried about, we can worry about AI, but I'm not worried about ultimately AI taking over everything, is that basically what AI does is it soaks up all the existing databases of content.
Yeah.
And then it's able to, sort through them and focus on it, organize it into something useful, maybe even to the point of, for example, being able to write new code and things like that. But what it cannot do, and this, which is this element that maybe a lot of people don't understand about the patent system, is that true innovation comes from the ether. And in fact, what's the test for getting a patent? Novelty and non-obviousness. And that's why we have an examination system, because you have to prove that. That's why the invention has to be something that is not obvious to one ordinarily skilled in the art and has never been known anywhere in the world before.
Yeah.
Unlike copyright, it doesn't, there's not a copying test. And so where's it coming from? Well, it's coming from somewhere out there in the ether. And it's interesting, when we used to have the first to file system, the first to invent system
For patents.
we had to have the
Interference.
interference, yes. But it's interesting that just an interesting phenomenon, I think, throughout history, is that you tend to find these inventions popping up all over the world.
Parallel inventions,
Yes. And it's otherwise it's sort of dawning on human minds, and so there's this metaphysical element to it. And that is not, I mean, who knows? I don't believe that is something AI can do or does. However, coming back to copyright, what AI companies are doing is that content database they're soaking up is data created by someone else.
Yeah.
And, under the current case law, basically, those content creators whose works have been are being used by this database have no stake in it. They have no right. And I think that is just fundamentally immoral. It started out with Google. I've always been against Google. When we had some cases, there was a famous case about
Google versus Oracle?
No, this was a copyright. It was Google was they basically digitized libraries.
The books.
It was a library case, and the Association of American Publishers, a lot of publishers brought litigation because, in my view, correctly, even if they weren't copying exactly, they were still making a commercial use out of the previous work.
Yeah.
And so as I recall, it's been a long time since I've read the case, but it was determined it was like a card catalog, for example. So, the court said, well, this is nothing more than, it's like a card catalog thing for, it's not the whole book. It's just because you're only, but if you do Google something, you will get whole excerpts. And
Right.
if it's in the area of, for example, visual arts, like I work a lot with professional illustrators, you'll see the whole illustration
Right.
often. And so that just opened the barn door. And then also going back even earlier in the software cases, the
Yeah.
transformative doctrine,
Yeah.
you know, in other words, if you transform the work, then, you know, you have a I can steal it
Yeah.
card. And all, so you had this whole period of weakening right at the time you were having these new technologies, and particularly the Silicon Valley internet-based content companies just went to town with that, and now they're just the most awful, evil organizations on the planet.